Good afternoon, everyone. It is Tuesday, January 31st, and we're back in the House Healthcare Committee. And today we are taking up H62, which is an act relating to the Interstate Counseling Compact. And just to set the stage for a bit before our Legislative Council walks us through some of the language. So a compact is basically legislation that multiple states can come into. Often there's a trigger for it to become active. So you might need 2 states or 5 states or 10 states before that compact can become active. We cannot change the language of the compact. That's part of the process of making it easier for people to be able to provide services, as well as ensuring that each state agrees to the protections that are in the legislation. And Katie will go through, our Legislative Council will go through more. Because we cannot change the language, and it is a 43-page bill, I asked Katie to put together a section by section that we can walk through, which is still 5 pages long, single space. So there's still a lot to go through, but we're not going to be wordsmithing. So just want to put that out there. Then after Katie, we'll have our Office of Professional Regulation and Deputy Secretary of State here to talk about how they feel about it, because it does fall under OPR. And then we will have several other witnesses who are practicing providers who will provide their thoughts on it. So hopefully everyone has, like I said, the section overview. It's on our committee page, and we're going to just give our Legislative Council a second to bring everything up.
Thank you.
Sure.
Good afternoon. Katie McLean, Office of Legislative Council, and I am struggling with some
That's okay.
problems. I've signed on to, okay, so let's try again.
We're used to technical difficulties.
Okay, I think it's good at the moment. So it's nice to see everyone. I'm gonna pull up the document that Representative Houghton was referring to. And this is a summary. So what we're looking at today is an act relating to the Interstate Counseling Compact. And a question came up was, what is a compact? So a compact is a voluntary agreement. States don't have to enter into the agreement. But it's an agreement between multiple states in this case. And so you could choose to enter into this by and legislatively approving it through your normal legislative process. And you also, if you enter into it, have the capacity to exit from it at some point by repealing the statutes that you've enacted. So it's a choice to enter into this agreement. I did send along in advance of this, and I think it is loaded onto your webpage, is a map of the states that have already entered into the compact, so you can kind of see which states have entered. So it's already a functioning compact. The threshold was 10 states have to enter for it to be effective, and that has taken place. So you would, if you chose to approve this, you would be entering into an active compact. Other things to know, again, this has already been said, when you are looking at a compact, this is not like an ordinary bill that we look through, where we can sort of play with the language. If we're not comfortable with certain language, make amendments to the language. This is different. All of the states are enacting standard language. There's an agreement that all the states are kind of playing by the same rules, adopting the same language. And that's why when you're looking at a compact, you're not looking to change the language. You're sort of accepting or not accepting the language, accepting to join the compact or not accepting to join the compact. So I hope that sort of gives you a sense of what we're looking at.
Leslie, sorry, Leslie.
So what I learned yesterday is it's the first state that sort of develops the language. So what was the first state?
I don't know.
Okay.
Can I tell you?
Just curious.
And I can also just add, we have other compacts that we have entered into as a state. I know we did the nursing one, and I think there's a physicians one that we did as well. So just, this is not our first time coming into a compact.
Okay. Thank you. So this is the Interstate Counseling Compact. And you'll see that the term or the phrase that's used here is a licensed professional counselor. And as we walk through the language, they'll say, like who we're talking about these individuals might have a different title in every state. It depends what the state itself decides to call these individuals. For the sake of the compact, we're calling them licensed professional counselors. But here, this would be a licensed mental health counselor. That's how they're licensed in Vermont. So the first section of the compact is the purpose. It lists the following compact purposes: to facilitate interstate practice of licensed professional counselors, to improve access to professional counseling services. Professional counseling occurs in a state that the client is located at the time of counseling. Compact states retain the regulatory authority to protect public health and safety through the existing system of state licensure. And it also goes through a list of objectives that are part of the compact. I should just flag for you, this was a 47 whatever page bill. So I've done my best to consolidate all of the information, but there's a lot of nuance missing. So if you have a specific question, we'll have to look at this act itself. But this is an effort to sort of boil it down to the essential parts. Joe?
Very small question. I noticed that there's subchapter 1 that has the 3 stars, meaning it doesn't matter. Is 3261 through 3264 becoming subchapter 1? And then 3261, I think it's 74. I might have miscited that. So basically the law that's already in that chapter is becoming the new subchapter, and this is creating a second subchapter.
Exactly.
Got
Yep.
it. Cool. Great. Thanks.
Okay, definitions. There is pages of definitions. I've just tried to flag some that might be most relevant as we walk through. So one definition is that of a commission. It's the national administrative body whose membership consists of all states that have entered the compact. So meaning that after a state enters the compact, it has a delegate from each state that works as part of the commission to administer the compact. So it's sort of the administrative body for the whole compact with representation from every state. We also talk about an encumbrance on somebody's license. That's a revocation, suspension, or limitation on full unrestricted practice of a licensed professional counseling by the licensing board. We've already talked about who a licensed professional counselor is. It's a counselor licensed by a member state, regardless of the title used in that state. In this case, it's the licensed mental health counselor, to independently assess, diagnose, and treat behavioral health conditions. And we have a definition of what do we mean by professional counseling: assessment, diagnosis, treatment of behavioral health and conditions by a licensed professional counselor. Okay. So moving along, there's a section on state participation in the compact. What do you need to do to participate? First, you have to, as a state, license and regulate licensed professional counselors. You have to require licensees to pass a national exam approved by the commission. Require licensees to have 60 semester hours or 90 quarter-hour master's degree in counseling or graduate coursework and specified topic areas. You have to require licensees to complete a supervised postgraduate professional experience as defined by the commission. And also you have to require or have a mechanism in place for receiving and investigating complaints about licensees. So that's what's required for a state to participate. Member states are required to participate in the commission's data system. There's a central data system where all information about licensing individuals is stored. So you have to agree to participate in that. You have to notify the commission in any adverse action or the availability of investigative information about a licensee. You have to implement or utilize procedures for considering applicants' criminal history records. Comply with all commission rules. Just like a legislative body, the commission can adopt rules that are in addition to the compact itself. All the states sort of weigh in and have a vote. So this is saying, yes, the state will comply with these additional rules that the commission might come up with. Next, require applicants to obtain or retain a license in the home state and meet the home state's qualifications for licensure or renewal. So that's important. Every individual counselor who wants to participate, they have a home state that they're practicing in. So here we would have individuals who are licensed and registered here and they want to participate and have a license and work in multiple other states that are members of the compact. They first have to have a home state license. Lost my see, comply with commission rules, home state license, grant privilege to practice to licensees holding a valid unencumbered license in another state. So that means if you're entering into this compact, there are going to be individuals from other member states who want to practice in Vermont. And part of the compact is allowing those individuals to practice in the state of Vermont if they don't have an encumbrance on their license. And then provide for attendance of the state's commissioner at council and compact meetings. So making sure there's a Vermont delegate at the commission meetings. This also allows member states to charge a fee for granting privilege to practice in their state. So if you are a home state and you are allowing, by joining the compact, allowing individuals to practice here from out of state, this allows the state to charge a fee to do so.
Let's get through all the bullet points and then we'll come back. Not all the sections, just what the section that we're in.
Allow individuals not residing in a member state to be able to apply for a member state's single state license, but a single state license granted to these individuals shall not be recognized to granting privilege to practice to other member states. So if you're if you're a licensed counselor working in Vermont, you can choose, if we become part of this compact, maybe you only want to practice in Vermont. You can still do that. You can just get a single state license in Vermont. Or you could still choose to be part of this multi-state program and have a license to practice in multiple states. And then a license issued by a professional counselor, a license issued to a professional counselor by a home state to a resident in that state shall be recognized by member states as authorizing the licensed professional counselor to practice professional counseling in each member state. I'll pause there.
Right. Art, go.
Yeah, one thing I noticed as we looked through, there were no fees anywhere, and I understand that because we're trying to do it. Do we know the fees other states have for granting the privilege to practice in their states? Do we know that?
I see the OPR popped up, so I'm hoping that they might have an answer to that question.
Okay, I mean, we don't need to go on now. I just wanted to see if we did know it, that's
They'll
all.
be able to answer some of the questions, hopefully, and if not, we can get some answers for you. Go ahead.
So is there a distinction between a single state license and a compact license? So if I'm want a mental health counselor license, would I have to choose between, when I go to OPR, between getting a single state license or a compact license? Or does my single state license entitle me to a compact license if I so choose to apply to the commission for that broader thing?
Administratively, I'm not sure how OPR would handle that, so I would defer to OPR to sort of tell you how they administer the compact.
Great, thank you.
Okay, I think I read when there were 17 states in the pact already, maybe.
I'm not sure the exact number.
But anyway, I think so. But do they all have this same, all the new ones that want to join, is this the same bill?
This is the same language every
Okay,
state
same language
adopts.
for
Yeah.
each state, thank you.
Yeah. Okay. I'll keep running along. I know this is very dense. Okay, so the next section has to do with privilege to practice. And this is sort of the phrase used throughout the compact to mean you're practicing in a remote state, not your own state. You have privilege to practice. So to exercise the privilege of practicing in a remote state, the licensee has to hold a license in its home state, have a valid social security number or national practitioner ID, be eligible for privilege to practice in a member state on the basis of certain criteria that's met in this section, not have any encumbrance or restriction against any license or privilege to practice in the preceding 2 years, notify the commission that the licensee is seeking privilege in a remote state or states, pay applicable fees, including state fees, meet continuing competence and education requirements in the home state, meet any jurisprudence requirements of the remote state or states in which the licensee is seeking privilege to practice, report to the commission on any adverse actions, encumbrances, or restrictions on a license by a non-member state within 30 days. So if you're working in a non-member state outside of the compact and your license is affected with a an adverse action, you have to notify the commission of that. Keep going. Okay. So the privilege to practice expires on the expiration of a state license. So you have to have that state home license in order to be able to practice in another state. Licensees providing professional counseling in a remote state under the privilege to practice must follow the law of the remote state. Licensees providing professional counseling in a remote state are subject to the remote state's regulatory authority, which may include removing licensees' privilege to practice for a period of time, imposing fees, or taking other action. And licensees may be ineligible for privilege to practice in other member states until a time period has elapsed or the fine itself has been paid. If the home state license is encumbered, the licensee shall lose the privilege to practice in remote states until the home state license is unencumbered and the license has not had an encumbrance or restriction on it within 2 years, the preceding 2 years. A licensee may lose the privilege to practice in a remote state if the privilege to practice is removed from any other remote state until that period of time has elapsed, fines are paid, etc.
Joe?
Okay, we're gonna need the bill for this one because this is a doozy. Sorry, but I want to start by saying I strongly support this idea. Under emergency rules, my mental health counselor is in California, and so is helping me under emergency rules. And so like this is something I very strongly believe in and personally know the benefit of. But I have a pretty big concern about 3275D that I'm hoping that we can dig into, which is of course involving the privilege to practice. So I sort of want to orient to a couple of different provisions that I want to point out that I think are important here. So first of all, looking at 3275DA8, which is
Can we just hold on? So for those who want to follow along, what page are you on?
I'm on page 11 of the bill. It's the final provision, lines 19 and 20
Okay.
of, so that's one pin I'm putting in here. The second pin I'm putting in, so I'm going to refer to all these different sections and asking my question, is involving 3275DC, DD.
What page is?
That is page 12.
Page and line number.
Page 12, line 10.
Great, thanks.
And basically going through the rest of page 12. So those are the first two areas I'm going to be referring to. I know we haven't gotten there yet, but it's sort of necessary for me to ask this question. I'm also looking at 3275GB, which is page 16, lines 16 through 18. In particular, looking at line 17, 18 regarding adhering to the laws and regulations of the remote state. I have problems with all 3275H involving adverse actions. I'm going to be referring to things in there. And then ultimately going all the way to the end, very last page.
Very last page of the bill.
Yeah, very last page of the bill. I'm on the bill at this point. Page 42, in 3275O, C and OF. So oriented to there. Now I'm going to ask my question.
I'm going to actually ask you to hold.
Okay.
Let's go through the rest of this.
Okay.
And we'll come back at some point today to that.
Great. Sounds good to me.
Okay. So next, we're looking at the section on obtaining a new home state license based on privilege. So first, a licensed professional counselor, as we've said, can only have one home state at a time. The bill details the process by which a licensed professional counselor could change a state of residence from one member state to another member state. If a licensed professional counselor changes the state of residence by moving from a member state to a non-member state or vice versa, the state criteria shall apply for a single state license in a new state. The compact does not prevent the licensee from holding multiple single state licenses, but for the purposes of the compact, there's only one home state. So this doesn't, right now, under the current system, licensed mental health counselor could apply to have several single state licenses. So somebody might be applying for a state license in Vermont and a state license in New Hampshire. The compact doesn't change somebody's ability to do this. What the compact does say is that you can only have one state for the purposes of the compact, the one state that it's responsible for you. There's a section on active duty military personnel and their spouses and how to determine where that person's home state is. Next, there is a section on compact privilege to practice telehealth. It says that member states shall recognize the right of professional licensed counselor to practice professional counseling in any member state via telehealth under privilege to practice. And next, that the licensee providing professional counseling services in a remote state shall adhere to laws of the remote state.
So can I just clarify on the first bullet point? This is saying that the professional would be able to practice telehealth based on the home state telehealth laws.
Yes, let me read that again. Well, I think
Or
it's
under the
broader
state,
than that.
under the state, wherever the
Yes.
person is. Okay.
Member, yes.
Wherever the patient is.
Wherever the patient is. Okay,
Right, yeah.
great.
Okay, so the next section is adverse actions, meaning an action against somebody's license. A remote state, so you're not your home state, but the remote state has the authority to take an adverse action against a licensed professional counselor's privilege to practice within that member state and issue subpoenas for hearings and investigations requiring attendance and testimony of witnesses and the production of evidence. Only the home state can take adverse action against a licensed professional's license issued by the home state. So only your home state can take away your home state license. With regard,
We're gonna go through the bullets and come back.
Okay.
with regard to taking adverse action, a home state shall give same priority to reported conduct received from a member state as it would the conduct occurring in the home state. So if a remote state reports that there was conduct in that remote state and reports it to the commission, the home state will respond in the same manner as if that conduct happened within the home state. With regard to taking adverse action, a home state shall get, I already read that one. Home state completes any pending investigations of a licensed professional counselor who changes primary state of residence mid-investigation. The home state is authorized to take appropriate action and promptly report investigations to the administrator of the data system. So this is the kind of the big data system that the commission holds, that holds all the data about licensees within the compact states. And then the administrator of coordinated licensure IT system shall promptly notify the new home state of any adverse actions. A member state can take adverse action based on factual findings in a remote state, from a remote state. The act provides guidelines on joint investigations between member states. If an adverse action is taken by a home state, the licensed professional counselor's privilege to practice in all member states will be deactivated until all encumbrances on the home state license are removed. And the compact does not prohibit a member state to participate in an alternative program in lieu of adverse action. So in other words, if your home state license has an encumbrance on it in some way that jeopardizes your ability to work in remote states under the compact. I'll pause there.
Ari?
Thank you. The first bullet point about the remote state having authority to issue subpoenas for hearings and investigations, is that talking just about within the jurisdiction of the remote state's licensing board, or is that criminal subpoenas for criminal investigation, or both?
I have to look at the language. I was thinking just the licensing board, but let me confirm. See, it says issue subpoenas for both hearings and investigations that require the attendance and testimony of witnesses as well as the production of evidence. Subpoenas issued by licensing board. and a member state for the attendance and testimony of witnesses for the production of evidence from another member shall be enforced in the latter state by any court of competent jurisdiction according to the practice and procedure of that court, applicable to subpoenas issued in proceedings pending before it. The issuing authority shall pay any witness fees, travel expenses, etc. So the subpoenas are issued by the licensing board.
Okay. I'm asking in part because in context, remembering the case in, I don't remember what state, with Redonda Vaught being criminally charged for a medication error that caused the death of a patient. But it sounds like that's a separate problem that would be addressed through a separate entity. Okay.
I hear your concern. I'm not 100% convinced that this, and this I'll get into later in part, I'm not 100% convinced that this provision doesn't necessarily open those subject to the compact to those subpoenas. I think it's a little vague.
So we can put that as a question mark for further discussion. Maybe.
Yes.
Sure.
I'm just wondering if there's been any action taken against a professional using any of these, you know about that?
That would be a better question for folks at OPR.
Yeah, I'm just curious how it's been implemented.
All right, let's keep going.
Okay. Next, establishment of the Counseling Compact Commission. So as we already said, there is a commission that oversees the compact and it has a delegate from each of the states that participates. So first we have language that creates the Counseling Compact Commission by member states. It discusses venue and judicial proceedings brought by or against the commission shall be brought where the principal's commission's offices are located, which I believe is in DC. Each member state has one delegate selected by the state's licensing board, who is either an administrator or member of the state licensing board. The commission meets at least once annually. And then there's a list of commission duties. Establishing commission fiscal year and bylaws, maintaining financial records, taking actions consistent with the compact and the bylaws, promulgating rules which are binding on members of the compact, handle legal proceedings in the name of the commission, purchase and maintain insurance and bonds, borrow, accept, or contract for services, hire employees, elect or appoint officers, fix compensation, accept donations and grants, lease, purchase, and accept gifts, manage commission property or acquisition, disposition, or property, establish a budget, make expenditures, borrow money, appoint committees, including an executive committee, and providing and receiving information, and cooperate with law enforcement agencies. Then generally subsection D of this section describes the duties of the executive committee. Subsection E outlines the requirements for commission meetings. Subsection F outlines how the commission is financed. And subsection G describes immunity from suit and liability for members, officers, employees of the commission.
Any questions on that section? Joe?
So DC is where we think it's where it is?
I believe so, but I'd have to confirm.
Okay, I'm just curious because of the venue. And
Later in the compact, it references the court, the district court of DC, which is what made me think that, but I would have to pull up their compact's website to confirm.
Great, thanks.
Kentucky,
Did they have Kentucky on it?
well, that's the address for in the counselingcompact.org.
Oh, it's Kentucky. Oh, okay, there we go. Kentucky.
Close to DC.
Yeah.
This will relate to my question later, but I'll put a pin in this as well. We are consenting to jurisdiction of Kentucky's courts.
Yes.
Just want to throw that out there, that, essentially we are saying that any issues involving this will be located inside Kentucky's courts in Kentucky's, Kentucky's jurisprudence, their precedents and everything like that. Their laws and everything. So, yeah.
Go ahead, Katie.
Thank you. So the next section is pertains to the data system, which we've referenced already. It directs that the commission shall provide for the development, maintenance, operation, and utilization of a coordinated database and reporting system pertaining to licensure, adverse action, and investigation information on all licensed individuals and member states. Member states are required to submit uniform data to the data system. Member states contributing information to the data system may designate information that may not be shared with the public without express permission. Any data submitted that is subsequently required to be expunged by the laws of the member state shall be removed from the data system. And then we have a rulemaking section. This authorizes the commission to adopt rules and amendments to rules within the scope of the compact's purposes, which are binding on members. If a majority of the state legislatures of members states reject a rule adopted by the commission in the same manner that it adopted the compact, then the rule shall not be in effect. So in other words, if a rule is proposed and adopted and the legislatures, so it would come back here, the rule would come back to the legislature. A majority of the state legislatures don't agree with the rule and it is not adopted by statute, because that's the process that we're going through here to adopt the compact, then the rule wouldn't be in effect. This also describes the process for proposing and promulgating rules, including it gives direction on notice and opportunity to be heard, and it describes the process and criteria for promulgating emergency rules.
Okay.
Okay. Next, we have a section on oversight, dispute, resolution, and enforcement. Directs the executive, legislative, and judicial branches of member states to enforce the compact as it has the standing of statutory law. If the commission finds that a member state has defaulted on the performance of its duties under the compact or rules, the commission shall provide written notice to the defaulting state and other member states of the nature of the default and the proposal for curing the default, and provide remedial training and technical assistance to that defaulting state. A state that fails to cure the default may be terminated from the compact on a majority vote of member states. The commission is not responsible for costs related to a state that is in default or has been terminated. The defaulting state may appeal to the commission action by petitioning the U.S. District Court of District Columbia or the Federal District Court where it has its federal office. Member state can request to attempt to resolve disputes with the commission via dispute resolution, and the commission is ultimately responsible for enforcing the provisions of the compact. Okay, the date of implementation of the Council and Compact Commission, associated rules, withdrawal, and amendment. So the compact is in effect when the 10th member signs, so that means that the compact is currently in effect. Member states that join the compact after, once it's already in effect, are subject to all the rules that are in effect when the state joins. Member states may withdraw from the compact by repealing the statute. Withdrawal does not take effect until 6 months after enacting the repealing statute, during which time the state's professional counseling licensing board continues to comply with investigative and adverse action reporting. So in other words, if at some point in a future legislature this were enacted and the future legislature says we don't want to be part of this compact anymore, you would repeal the statute. But after the date of enactment of that repeal, it would be 6 more months that the state would still be part of the compact. It wouldn't be an automatic repeal. The compact does not prevent a cooperative arrangement between a member and non-member states. So just because you're entering into a compact doesn't mean that Vermont couldn't enter into an agreement with a state that's outside of the compact. There's language about construction and severability. It says that the compact is construed liberally to effectuate its purpose, and severable if any provision is found invalid. So that means that the rest of the compact would stand, even if that one provision was found to be invalid. Binding effect of the compact. So a licensee providing professional counseling services in a remote state underprivileged to practice is to adhere to the remote state's laws and regulations. The compact does not prevent enforcement of any other member state law that is not inconsistent with the compact. And the compact supersedes laws of a member state in conflict with the compact. A compact exceeds the constitution of a member state, the provision in question shall be ineffective. And we have an effective date of September 1st this year.
July, maybe? What was that, July?
Oh, sorry. Yeah.
So I don't want to go back to your earlier stuff yet. So is this something more recent?
Nope, it's the earlier stuff. It is sort of like a leg council question though.
Okay, so if you're going to reference the actual legislation, we just need to slow it down so we can all.
And we're not lawyers, Dave.
Yep. So I'll ask my question and may point to various rules, various provisions of this bill as I ask my question. So my main concern is with 3275D, which is privilege to practice. And there's a few things in here that are bothering me.
Page again.
Sorry, that's page 11.
Thank you.
Part of the requirement is we meet any jurisprudence requirements of the remote state. And we just talked about in the later section about how the person is subject to the laws of the remote state while helping, counseling a person in that remote state. In addition, and this is where my rubber meets the road concern about my concern here, is that this is, I just want to get my reference right. This is 3275 DC. A licensee providing professional counseling in a remote state under the privilege to practice shall adhere to the laws and regulations of the remote state. And then D, a licensee providing professional counseling services in a remote state is subject to that state's regulatory authority. The remote state may, in accordance with due process of that state laws, remove a licensee's privilege to practice in the remote state for a specified period of time, fines, yada, yada, yada. So here's my concern, is that last year, the United States Supreme Court ruled in Dobbs versus Jackson Women's Health, which repealed Roe versus Wade. As part of that, we now have a fracturing when it comes to laws regarding abortion in this country. And some states, in particular, I'll point to Texas, have adopted a provision that allows any person to file a lawsuit against anyone who is involved in helping someone get an abortion. I very well can see a situation where a Vermonter moves to Texas or another state with similar laws, is working with their counselor and decides that the best thing for them is an abortion. Someone was to find out about that. Obviously, there is, patient confidentiality there, but if someone was to find out about that, I am very worried about the fact that, number one, a person could take an action against the license of a Vermont provider in, let's say, Texas. I'll use Texas as the example here, saying that was a violation of the state laws with regards to abortion. This will then have a cascading effect on that person because Section D goes on to say the licensee may be ineligible for a privilege to practice in any member state until the specific time for removal is passed. So this now has a fracturing effect where this now causes this red flag to go in this database, which now points out to every other state they're working in that there may be a problem since we don't have a singular abortion policy in this country anymore. I'm concerned about the impact that can have. And I'm doubly concerned about the chilling effect of this because we see in 3275H(D), which is page 18, lines 8 through 11, a member state, if otherwise permitted by state law, may recover from the affected licensed professional counselor the costs of investigation and disposition of cases resulting from adverse action taken against that licensed professional counselor. So I could certainly see a situation where a person from Texas, a Vermonter who is helping someone in Texas under this law has an adverse action taken against their license. And then this law requires that Vermonter to pay the costs of that. And that's problematic because in the Vermont Constitution, we have free speech. In the Vermont Constitution, we also have Article 22, which makes very clear about our approach that we are taking in this case, which is a strict scrutiny approach for anything that may inhibit on someone's reproductive rights. And then I move on to my final concern before sort of turning this over for you to answer, or for the group to discuss, is if we look at, and I have a lot of notes here, so like I could point to other provisions, but I'm trying to keep this brief. If we look at 3275-0C, which is page 42, line 9 and 10, any laws in a member state conflict with the compact are superseded to the extent of conflict. However, we presently have in front of the Judiciary Committee H89, which is the SHIELD law, and I'm really worried about the possibility of a Vermonter doing this work, helping someone make the difficult decision to get an abortion that's in one of these states that doesn't recognize that right any longer, thinking that they're protected if the SHIELD law is to pass, and this is to pass, thinking they're protected by the SHIELD law. And yet, we have a very clear provision here under 3275-0C that says that the SHIELD law does not apply to those people, because we are saying this supersedes everything else. And so, frankly, I also don't feel comfortable just saying, well, let the judicial branch figure it out, because it's sort of, I think there is a constitutional issue here that could have a really big impact on providers, unwittingly doing something, thinking they are protected, and it turns out that they're now subject to bearing the costs of investigation in every single state that is now taking an adverse action against them for them expressing their constitutionally protected rights in Vermont regarding free speech and regarding reproductive liberty. And so
I'm going to stop you there.
I'll stop.
I'm going to stop you there.
Yeah.
I'm going to say Katie can respond if she wants to, but this has been thought about. So you bring up very good points about all of these compacts that we're looking into. And I'm going to ask you to hold this unless Katie wants to respond until OPR comes and testifies.
Okay, sure.
Art.
I just had a question, it's probably in here somewhere and I might have missed it. A state, and Lori, you might be able to answer this better, but a state that's not in the compact, can we still do telehealth with states separately?
I'm going to let Katie actually answer that one, but
So this doesn't impact the relationship that Vermont has with states that are outside of the compact. The status quo as it is now.
Okay, as it is now, and they're outside of this, but we can still, like Joe mentioned it, the thing in California, I forgot the map, I don't know if they're part of it, but if they're not, we can continue to do those things.
Yes, the status quo as it is now would be.
All right, thank you.
Okay.
any other questions for Legislative Council? Great, thank you, Katie.
You're welcome.
So we are now having Lauren Hebert, who's the Deputy Secretary of State, and Lauren Lehman, who's the staff attorney for OPR, come up and join us. And for those who have never met either, they're wonderful to work with. So have a lot of information for us. Yeah, make some mistakes there. Sorry. Okay, great. Welcome. It's good to see you both.
For the record, Lauren Hibbert, Deputy Secretary of State, and I have with me
Lauren Lehman, General Counsel for the Office of Professional Regulation.
Great.
Thank you so much for the opportunity to come testify in front of you today. We did file some testimony if you want to follow along, but we thought just before we jumped into the logistics of this compact, since this is the first time we're testifying in front of your committee this session, some changed membership, that we should just give an overview of who the Office of Professional Regulation is, what our mission is, the work that we have been doing around expanding access to licensure, and then a brief overview of occupational compacts, and then we'll go into this specific compact. I understand that we've got lots of compacts.
Yes, coming
So-
up quick.
So the Office of Professional Regulation regulates 51 professions. We have many of the healthcare professions. We regulate all of the healthcare professions with the exception of allopathic physicians. So there's two different types of physicians, osteopathic and allopathic. PAs, podiatrists.
His PA is.
Oh, physician's assistant, sorry, thank you. And podiatrists, which are all regulated by the Medical Practice Board. But the remainder of the healthcare professions, so everything from an acupuncturist, a dentist, a nurse, a physical therapist, an OT, SLP, which is speech language pathologist, are under our umbrella, and it also includes all the mental health professions, with the exception of psychiatrists, who are by majority allopathic physicians. So we established qualifications for licensure through statutes and then administrative rulemaking by profession. And we also receive complaints about unprofessional conduct. We have an enforcement team that investigates those complaints. We have 5 certified law enforcement officers, 3 civil investigators, and 4 prosecutors. We look at our cases from both a regulatory licensing board perspective and a criminal perspective. We do not pursue the cases criminally in-house, but we can refer them out to local law enforcement or the AG's office or the federal law enforcement. Our core mission is to protect the public. That is our grounding mission in every decision that we make. And in recent years, we've been on the forefront of a lot of changes in occupational licensure. We received a Department of Labor grant that focused on reducing and streamlining barriers to occupational licensure. We looked at it specifically through the lens of certain groups, people with a criminal background, new Americans, and military families. We also looked at reducing barriers to entry, particularly for those people where college would be and student loan debt would be a barrier to entering the workforce. So that is OPR in a nutshell, and I'm happy to answer any questions about the Office of Professional Regulation if anyone has any questions.
Is there, for every profession, the same fee and revenue fee, the fees as revenue set up as there is for nursing?
Wait, is this Ways and Means? Am I in the wrong committee? I'm testifying in Ways and Means tomorrow about fees, so I'm well prepped for this question. Every profession has an application fee and a renewal fee, and the OPR budget is a special fund. So that means we do not receive any general fund money. And then we have 2 different ways that we regulate professions. We have the board model and we have the advisor model. And in the board model, which is nursing is one of them, we have 16 boards. In the board model, the board's money has to be siloed in and of itself. So the Office of Professional Regulation cannot use nursing funds to subsidize dentists or vice versa. And so we look at fees. In the advisor model, we can pool the money across professions, and it's a little simpler to sort of adjust fees specific to earning potential or what's happening in the marketplace. So for the nursing board budget, we're looking to try and make the nursing board budget stable with the nurses that we have who pay licensing fees in our state within that silo. Does that answer your question?
Getting at my question to the nursing compact issue,
Yes.
where that it's interesting to know that the other professions are not structured by board.
Some are and some aren't, Representative Gordon. Some profession, we have many, dental board is a board, the psychology board, the Allied Mental Health Board, which is the board that this compact would affect, all are board models. So those fees are siloed within the board.
Just for the benefit of the committee, my concern about the nursing compact, which is a board structure, which may or may not be an issue for other professions was that the nursing fees, licensing or renewal, are what provides the operational revenue for that silo or that section. So if there are any changes, it has a direct impact on the fees that nurses pay for licensing and renewal. So that's why I brought that up last year and was asking this year.
Yeah, it's a very relevant question this year. It's going to be a relevant question to every discussion of every compact. And you've just jumped ahead like 3 bullets on my presentation, which is totally fine. So when we joined the nurse licensure compact in 19 and 20, there was a very active conversation about the loss of revenue, because we could tell that we were going to lose about a fourth to a third of Vermont licensees, because we have so many out-of-state nurses coming into Vermont. And if you think about Legislative Council's presentation, what the compact does is it substantially changes the operation of somebody coming to Vermont and working with their license or providing telehealth to somebody who lives in Vermont. Because before there's a compact, that professional needs to get a license in Vermont. And that means a fee in Vermont, and a fee that's paid to OPR. And compacts handle this issue differently. And Lauren will go into that. But it does have a revenue impact on Vermont to join a compact. And it is something that we are watching and trying to anticipate and foresee the impact, sometimes imperfectly, but that is something we're very aware of.
And there is a report, the nursing compact bill required that a report from OPR come back to relevant committees in January of 2024.
That is correct, because we are going through the first RN renewal since the compact was implemented. And the RN renewal will be complete. The deadline is March 31st of this year. And so we'll have a much better understanding after the 31st of March, exactly what our fiscal impact is as a result of the compact. And that's why the timing of the report is for after that renewal cycle.
Ask one last question about that. And do you, maybe looking into the future too much, but do you think there's a possibility that legislature may need to intervene to help make changes?
What are you
about that
doing
structure?
Tomorrow at 1:00?
Yeah. Okay, is that ways and
No,
your ways and
that's Ways and Means conversation. Yeah, I think that there is work that needs to be done on how OPR is fundamentally structured. And that is because, if I could just say, we've really been trying our best to be progressive in like the small p concept of progressive, trying to increase the workforce, trying to do all of these policies to make it faster, easier for someone to get to work in Vermont. We really see ourselves as a partner with the healthcare institutions and honestly with the entire workforce. That has come at a cost to OPR, and including compacts. Compacts are a really good solution for mobility across state lines, for telehealth, for getting someone who's working in Connecticut today to be able to work in Vermont tomorrow, right? It's a perfect solution for that. It has an impact on our revenue, and all of these solutions don't decrease the amount of work that the Office of Professional Regulation is responsible for. So just because somebody doesn't need a license in Vermont to practice doesn't mean that the office is not responsible for overseeing their practice, ensuring it meets our standards. We also have very similar concerns in the post-Dobbs world around abortion, and in this profession specifically, gender affirming care. But we also have protections for this profession with conversion therapy. There's a ban on conversion therapy. We want to make sure that counselors who are providing care to Vermonters adhere to our laws too. Even if they live in Texas, even if the counselor lives in Texas, is providing, it goes both directions, right? So it's a little bit of a legal kerfuffle And we're trying to navigate it the best that we can. But that is the post-ops world is of concern for us, and Lauren can speak more closely to that with regards to this compact. But I guess, Representative Cordes, to your question, we know that there's a fee impact with a lot of the compacts. And the issue is that the person doesn't have to pay a fee to work in Vermont under a compact. And it doesn't necessarily reduce the work that the office has to do.
Yeah.
So,
Thank you, that's very helpful.
And if I can just add to this conversation in that our goal here is to determine if this is a policy initiative that we support. It is not our goal to determine what we should do about fees. That is across the hall. We will work closely with them. We have a committee liaison here who will work with Ways and Means, so we'll know what's happening. But our goal is to look at the policy, and is this the right way for our state to move forward?
So high level, back to compact, high level presentation. There's lots of compacts that operate in our world. The most common is the driver's compact. That's where a driver in one state has permission to drive in another state. That's all done through compacts that are written into all 50 states' laws. And this is a similar concept. With a driver's license, you have a home state, and you have the authority to drive in New Hampshire or Maine because of that compact. The home state is usually where you live and vote. Some compacts have little nuances around the definition, but that's typically it. And if someone moves, then they have to change their compact state. So similar to, again, back to the driver's license, because that's what we all have. You know, if you move to Connecticut, you then have to get a driver's license in Connecticut. Similarly, if I'll use nursing because that's the compact we have most now. If a nurse who's a compact nurse in Connecticut moves to Vermont, they have to get a new home state license in Vermont, a new compact license. And then there can be some compacts are structured differently. Some allow you to practice without any notification to the compact commission or to the state where you're going to be practicing. Others require some type of notification, and some compacts require the payment of an additional fee. And then there are, again, back to high level, they're really effective tools in interstate mobility and telehealth. This committee last year did substantial work around creating telehealth across all of OPR's professions. Thank you. And that basically was because we knew that compacts were not coming in the majority of those professions for the foreseeable future. So the next point is there's always some sort of revenue impact, and it's different depending on the structure of the compact. And it's really relevant to Vermont because we are a small state. We have small state problems. You know, we have people that live in New Hampshire that always work in Vermont. We have people who we have a hard workforce to manage. And then we also don't have the economies of scale. So if you think about it, New Hampshire has, 50% more licensees than we have, and their operating budget is not that much. It's not 50% larger. It doesn't need to be because their IT system is not going to cost that much more than ours. The compacts also impact the enforcement process. We retain jurisdiction over anyone who's practicing in our borders or who's practicing with somebody who resides in our borders at the time of this instance, the time of the counseling. So this is a really important thing to Vermont. If we believe in occupational licensure, it is back to the principles of federalism, is that Vermont should have control over who is providing care to her citizens. And we want to make sure that that care meets our standards, and we need to have that jurisdiction. And then, as I've already talked about, we are very aware of and concerned about post-obs with specifically abortion care, gender affirming care, and conversion therapy. all of which sometimes have additional protections for our Vermonters and are actively being attacked in other states. And with that, I'm going to turn over to Lauren to talk about the counseling compact. Great.
Any questions for Lauren before I start? So I'll talk directly about the counseling compact. Kate did a great job. For some of the questions, the compact itself was developed by the Council on State Governments, which is an organization that receives grants from the Department of Defense and other organizations to develop these compacts, has done so in multiple professions at this point. They also developed the Audiology and SLP Compact, which you'll probably be hearing about, the OT Compact, Occupational Therapy Compact, and SciPact. They're in the process of developing a social work compact.
And I'm just going to interject. Lauren's not going to toot her own horn. She's on the ground level writing the compact for the social workers.
Thank you, Lauren.
Well,
Very important.
Thank you.
So, I'm sorry, so the social workers have a separate compact than counselors?
So this is just specifically to counselors. Some states call them licensed professional counselors. Vermont calls them licensed clinical mental health counselors. We also have about 8 other mental health professionals, from the rosters to psychologists to social workers to alcohol and drug counselors, psychoanalysts, marriage and family therapists. So this is one silo of a profession. Compacts do work in that kind of very specific way because you're creating an agreement to say, I'm relying on your state licensing processes to verify this person's qualified and competent and safe to come practice in my state. So it's very narrowly tailored to just the clinical mental health professions. And the way most compacts work is there's a trigger level of states to join the compact. And then once that number joins the compact, a commission is established, a centralized commission. And that commission then establishes rules for the implementation of the compact. The counseling compact reached that trigger level last January, in January 2021, or 22, excuse me. And so their commission just convened for the first time this fall. So they will not be offering the privileges to practice until later this year, early 2024. That's a good place for us to be in terms of joining, if the state does choose to join, because we can be a voice at that table in terms of the rule development. And that comes in a lot to your concern, Representative Apriano. The venue, I did want to clarify that the venue of Kentucky is only when the member states are fighting about the commission itself. They are not applying the venue of Kentucky to a licensee's discipline. So that's just the background. And we have 16 states so far who have joined this, including New Hampshire and Maine. So that for our local reciprocity is pretty great.
I'm sorry, let me ask a question. So if for some reason we do not pass this out this year, we would lose the opportunity to affect the rulemaking process. Like, let's say we wait until next year of the biennium for some reason.
You wouldn't lose the total ability, you'd lose the voice as things are being established.
Okay.
Rules will be continued to be established. OPR just worked closely with the Interstate Medical Licensure Compact, which I think the state adopted in 2019 to address the Dobbs concern and this reciprocal discipline issue. And we were able to go to a rules committee meeting, propose a change, work with other states who are already members to adjust a rule and adapt a rule to address this issue. Alternatively, I attended the first commission meeting back in October and mentioned the potential concern of that same reciprocal discipline and gender affirming care and conversion therapy. They were aware of that then, and that it brought awareness to the other states as well. And so when they go in to develop rules, hopefully they'll bring that awareness. If Vermont were on the commission and had a delegate, we'd have a voice in the room to continue to make sure that awareness is there.
Great, thank you. I'm just wondering, are there other council compacts coming down the road in this field? So like we're gonna do this every time for mental health counselor, every 12 different whatever?
So for counseling, there won't be more for the clinical mental health counseling. There might be a social work one. We're meeting next week to kind of work through the final stages of that. I don't know which ones will be brought before you. There's a psychology one, which is more limited in scope. There's a audiology and speech language pathology, not mental health, but that's coming. And then there's occupational therapy and physical therapy.
And we do have those last three.
Yeah, and I remember saying, I'm just kind of.
We'll have the last three.
The silos, I guess. I'm a little overwhelmed by that idea of having to go through each one.
You won't have to hear our spiel every time though, because you'll be
Okay, so
you'll be experts in
We'll just dive right into the Lauren Lehman part. You'll miss the Lauren Hibbert part.
make them obsolete.
But this is where occupational licensure is going, is compacts, because of the interstate mobility and telehealth.
With the telehealth and the great work you all did and the rules we're establishing, it's really going to allow out-of-state professionals to provide telehealth to our in-state population. But it's not going to allow our in-state professionals to provide outgoing care. And a compact allows that kind of reciprocal practice.
And that is because the outgoing states may not have the same telehealth regulations we do.
Only 2 other states have that at this point.
Could we, I want to expound on that. Say that again now. Only 2 other states have.
Telehealth licensing. So that's separate from the compact. Telehealth licensing is where an out-of-state professional, rather than get a full professional license to practice in Vermont, just gets kind of an abbreviated telehealth license. And then they can just practice telehealth in Vermont on a limited basis. Florida has it, and I believe South Carolina recently adopted it, but hasn't implemented it yet. So other states, though, are just now allowing their in-state professionals to practice telehealth. So they're far behind OPR in Vermont on that issue.
So what's the value of the compact?
Compact would allow, if you had a compact license, your Vermont is your home state, you have a license here, you could practice in any of these other 16 member states without getting any other license in that state.
Okay, but the opposite wouldn't be true of the other states that don't have a telehealth.
They're separate things, so 2 pathways. So with a telehealth license, with the thing we could build, all we can control is our own state laws. So we can let out-of-state folks work here, but we can't make the other state accept our.
Right, correct.
Compact allows it to go both ways with any state that's a member.
Okay, so it's more advantageous for our state than it would be for a state that doesn't have telehealth.
I think it's pretty parallel. I mean, I think this helps our professionals follow our patients when they go to college, go to vacation, snowbird.
Yeah.
Whereas the telehealth, we can't really do anything about it unless they snowbird in a state that has the telehealth practice, like Florida. If you're going to Arizona, you're out of luck.
Okay, but if not to beat a dead horse here, but if there's a child here from one of the member states, one of the compact states now, and we're not part of the contract pact. If that child is here and they're beginning the service from their state telehealth wise, will this compact do anything to that arrangement?
No. So this compact would be completely separate from that arrangement. If that arrangement wants to continue past July or June 30th of this year, that out-of-state professional should get a telehealth license here and continue to practice. That said, if we do join the compact and that child is from the provider for that child is from a state that's in the compact, they could just skip the telehealth license altogether and get a compact license and continue to provide care.
Okay. All right.
The benefits to that would be the telehealth license has some limits and patients, et cetera. And so it's up to the provider to choose. And the telehealth will still be a good option for those non-compact member states.
Okay.
But the compact really provides another pathway and another option. So back to the features here, a quick summary. Kate went through it really quick, really well. But, the premise here is that Vermont has to do certain things to become a member. We're lucky here in that the obligations for being a member, 9 out of 10 of them we already do. So we don't need to build a new regulatory system or statutory system to do it. We already require the 60-hour degree. We already require the 9 areas of study. It's not the case with other laws or other compacts, but for this one, we don't need to build a separate pathway. We, and a lot of them repeat what we do under the medical licensure and nurse licensure compacts. So we already share data there. We know how to do that. It's one of the things as a lawyer makes my heart hurt a little that we delegate this state lawmaking function to a third-party commission, but we've done it elsewhere and it's worked out well, especially when we had a voice in those conversations. And we already we have a strong mechanism, as Lauren pointed to, for receiving and investigating complaints. The FBI background check, we do that with nursing. Because of the nurse licensure compact, we don't do it for any of our other professions. We would need to new authority to do that background check of counselors. There are some issues with backlogs in terms of the operations of implementing background checks for a broad population. So we would need to look at resources too. And all of that, as Lauren pointed out, would take some time and resources to implement as well. It'd be a cost. Who's going to take those fingerprints?
So if I could just say, we would need an amendment to this bill to add authorization for us to get those fingerprints backgrounds into, it's in
123, sorry.
123.
Yeah. And that could be to the end, so it wouldn't amend the actual substance.
Amendment.
And I should also say at this time that one of the fundamental things, again, to what you said, it's an option. So there will always be the option to get a home state license to practice in Vermont and not go anywhere near the compact. If you don't qualify for the compact license, if you don't want to practice elsewhere, you always have that home state license. If you don't want the FBI background check, you can get a home state license and not bother. So there will always be that option. And then for the applicant, they need to obtain that home state license, get a license in Vermont or the member state. And this is a good part of this structure, is that it doesn't have as much financial benefit because this is a privilege to practice structure. To then go to another state to practice, the compact licensee has to tell the compact commission, I want to work in Vermont, New Hampshire, and Maine. And then they have to pay a fee to the commission to have that compact privilege to practice, and the state can take part of that fee. So the state can charge a fee for the privilege to practice here. It's not a whole fix. We probably can't charge the entire fee, but that we would for in-state practitioners, but we can pull down some funding. The fee, as you were asking about before, has not been established yet because the commission was just set up, but they'll establish it by rule in the coming days.
I'm going to ask a question first and then Joe. So if we move forward with this and then the rulemaking happens and next year, I forget when you said that would happen, or the next year the legislature says, we're not so sure about this anymore. We don't like the rules that were put forth. We can pull out of it.
You have to wait 6 months before it'll go away.
Okay.
But yeah, there's withdrawal provisions in there.
Okay, Joe.
If a remote state determines that a licensee has violated its standards of practice or its laws and takes adverse action against a licensee, is that considered to be an encumbrance on the license?
It would be an encumbrance, but the fix that we did for the medical licensure compact and that we've proposed to do here would make it so that it's not mandatory for the other remote states to then take action against that licensee. So it would basically be an exemption to that 2-year, you can't have an encumbrance on your license for 2 years to be eligible. And so that's what we've requested, some sort of similar accommodation be made to this. And I can share that language with the committee as well from the medical licensure compact and how they address this issue.
And so this would be sort of a rule that we would be proposing to the commission, and then it would be sort of up to the commission of whether it chooses to adopt that rule.
Almost in that we would be a delegate, we'd be part of the commission.
Right, yeah.
So we would be on the commission to make that rule as well. I should say it was also really well received by the commission. Whether you decide this is good policy or not, I do feel comfortable that they would be receptive to that kind of amendment.
Leslie and then Alyssa.
I'm just wondering if there's sort of standards of practice that are pretty much national in terms of, discipline that we wouldn't expect it to be that different from Vermont to Kentucky in this kind of profession, because it's overseen by a national kind of board.
Right, so a very standard violation of, prevailing and acceptable practice is having sexual relationships with your clients.
Yeah.
Because of the boundary violations. That's true in every state.
Right.
But when Dobbs was decided and when we started looking at the ramifications of Dobbs, at first blush, it took a minute to think through how this Dobbs was going to affect us, but it absolutely does because of these compacts. And because somebody is allowed, one of our licensees is practicing in another state in a very different concrete way. And the privilege to practice is tied to our home state license. And it's a much more complicated web when we're part of a compact. And to its credit, as Lauren said, the medical practice board, the medical compact, the IMLC, really tackled this and I think had a very robust conversation about how to solve it. And I think while it was a little bit of a jurisdictional push-pull, I think ultimately everyone wanted the value of the compact to sustain and to come to a solution where states were not withdrawing. And as soon as it became clear that states like Vermont might withdraw from the medical practice compact, people came to the table to find a solution. So we feel really confident that will happen in each and every one of these compacts where these issues are raised.
This is the mobility and the professional kind of exchange that this facilitates is so valuable to states and the populations of states that folks are working with it.
Listen, if I could just, sorry. If I could just follow up, I'm just looking at your map. And of course, there's states that worry about, Texas, but Florida's in the compact. So that's an interesting state. So I'm just a little stuck, I guess, on how we work through that really difference in philosophy, I guess.
So what we do is we say you and we do us.
What does that mean? Sorry.
We take out that kind of, so the provision in the compact that's troublesome is we have to give effect to your state laws for our licensees. And so because we have to discipline people in our state who are practicing in our state for a violation of your state's laws. Mm-hmm. The amendment to the rules allow us to opt out of taking that disciplinary action.
So if Texas disciplines somebody for providing gender affirming care, we would receive that discipline, we would receive notification, mm-hmm. we would review it, mm-hmm. and we would like the authority to say, no, we're not going to do reciprocal discipline on the basis of that discipline. It doesn't change that our licensee was disciplined in Texas. And I actually testified about this last week with regard to I think it was in judiciary. We want to make sure that Texas, even if we disagree with their philosophy and their application of their laws, we want to make sure that Texas has control over people who are practicing in their state and we have control over the people practicing in our state. And so when Lauren just said, it's you do yours and we do ours, mm-hmm. and we don't want to be as intermingled when it comes to reciprocal discipline, that is the solution to the
So one consequence, if I may, might be that they lose their opportunity to practice in Texas, but they continue to have their Vermont license.
Exactly.
Thank you. Listen.
I just wanted to clarify the applicants section that you were just reading. So you have your home state license, get your license, and then you say, I want to be compact. I want a compact license. You have to actually name the state. You're just not like all 15 or 16 or however many things on the map there were.
Yeah.
You name, I want this state. And then do you pay a fee per which states you want to practice in that are part of the compact, or one fee?
I think that can be developed. So you could pay a state fee for each state. I think the commission has to decide whether there'll be a flat fee and you can name as many states as you want, or if you'll have to pay per state. They haven't decided that yet. There are alternative structures like the nurse licensure compact. You get the compact license and you can practice anywhere. Then OPR in Vermont doesn't see any fee, any part of that. They pay for their nurse compact license and go. But with this structure, they do need to tell the commission in the state they're going to practice there and pay the associated fee.
So it seems like it's almost more of what we did last year with the sort of mini telehealth license. It doesn't seem like a compact. It seems more of a, I think I'd like to be licensed in this state too, and now I don't have to fill out the paperwork for that state.
Right, and you don't have to do an application for that state. You don't have to do the continuing education for that state. So that's, and then also with this profession, there's a lot of variation in state law. So you may qualify in one state and not qualify in another because you had 500 hours fewer supervised practice 20 years ago. So that sort of variation makes it really difficult to get in, like, just go get a license in every state.
Okay.
And so this facilitates that a bit.
Okay.
Joe?
I think I found everything you said about sort of the we do us, you do you, that's very compelling. I think one of my concerns is, though, sort of what you think about on page 18, which is just, I'll read it, which is a member state, if otherwise permitted by state law, may recover from the affected licensed professional counselor the cost of investigations and dispositions of cases resulting from any adverse action taken against that licensed professional counselor. And I just worry about, along with the subpoena powers that's also in this section, things like that. I mean, one thing I've discovered in my profession is that there's sort of two sides to the coin. One is what the law says, and I have a right to X, Y, and Z. And then the flip side of that is, do I have the financial resources in order to protect and assert my rights? And so I worry about and curious about your opinions on chilling effect. If I, as a licensed counselor, know that if I give this counseling to someone in, say, Texas, that I would be holding the bag when it comes to paying for Texas's investigation here, which might be significant. I don't know. I don't know how expensive that kind of thing is, but I imagine it's not cheap. Does that put a chilling effect on our counselors in being able to exercise their requirements under state law, such as providing gender affirming care and everything we talked about that we sort of see as expectations regarding reproductive liberty and everything like that in our state? Do we create an impossible situation for a counselor where they're stuck between a chilling effect and an obligation?
Right. And there might be a chilling effect. I think the answer is communication and education of counselors who get a compact license, that they're aware that where they're practicing is what is the law that applies. So if they choose to work in Texas, they need to know the laws of Texas. And if they choose not to work in Texas, that's fine too. They can also choose not to have a compact license if they don't want to, or if they get a compact license to work in New Hampshire and Maine, We always encourage licensees to be aware that they are subject, even without the compact, to the laws of the state where they're practicing, and to know those laws. It's been news to quite a few folks when we're doing the telehealth. And so I think that's really the answer to this, is maybe they should, if they're chilled, then it's okay to say that's a boundary I'm not going to cross.
Great, thank you.
And we keep talking about Texas, and Texas doesn't have this compact. So
That's why I brought up Florida. Florida does.
I know, but I want to be clear, because we keep saying Texas. Texas is not part of the compact. And back to the point of there will be education, as well as the fact that the counselor who's seeking a license in another state can choose which of the 15 states they do or do not practice in. So it is a choice the counselor can make.
They would have to pay money to practice in Texas. Or
Well,
Florida. Florida.
Not Texas, okay.
And Florida has a lovely telehealth law as well.
Yes, they do.
So, and they have some really great professional license laws, so they're not all bad, but yeah.
I'm gonna let Daisy go and then Art.
Can you walk me through what I would do if I were a licensed counselor in Vermont and this was enacted? And I thought, oh, I would love to sit in Vermont and maybe do some telehealth for our clients down in Florida. Would that be possible? Or would I have to be located in the same state as the clients I was serving?
No, it would be absolutely possible. So you would obtain your Vermont state license. If you had your license, you could go straight to the compact and say, I want to obtain a compact license and practice in Florida. The kind of, actually, the slight variation on that is you'd apply through OPR for your compact license, and then you'd get a compact license and go tell the compact which states you wanted privilege to practice in. That's what we do with the nurse licensure compact now. The application process would be simple because if you already have a Vermont license, it would be a 1-to-1. Okay, you qualify for the compact license.
And so there's not a separate, or do you anticipate there being a specific telehealth license?
There will be a separate telehealth license as well. That was established last session and will be built by the summertime. And that's even if we didn't join the compact, it doesn't affect the Vermont licensee who wants to provide telehealth in Florida, but it would affect the Florida licensee who wants to provide telehealth here.
So if you were at home in Vermont, you couldn't follow your patient to another state under the Vermont telehealth law. Only out-of-state professionals can come to Vermont to practice under the telehealth law. The compact gives the authority for in-state providers to practice in other compact states and for other compact state providers to practice in Vermont. So it goes both ways with the compact, whereas telehealth only comes into Vermont.
Because we can only control what we do here. We can't control what Michigan does, right? And we will talk about telehealth in here. We just haven't done that.
So this is opening up job opportunities to providers here.
Right, and so I think they'll talk about that during the benefits section. Art, and then we're gonna,
Confused about the tone.
okay, Art and then Alyssa.
Yeah, and all this now, I have one question, but I'll throw that out the window and worry about what I just heard here. Just trying to, so a counselor in Vermont could somehow have a friend down in Florida, say, or Louisiana, let's use that. And that friend has a child, say, or someone who needs counseling. So I can go physically there and do that, or I can do it via telehealth and do it that way. So I can do either with this license. But back to Alyssa's point, we're not necessarily selling there isn't one compact license you get, and then you can choose the states. You're getting separate licenses for these states, or don't we know that yet? It sounds like.
Well, we get you'll get a compact license from
Okay.
OPR, so one license, and then there'll be no application process or anything. You'll call the commission, or you'll email the commission, or you'll fill out an application and say, I want to work in New Hampshire, Louisiana, Maine. You'll pay the fees and then be able to work there. So it's a selection. Once you obtain the compact license, it's just a selection process of which states you want to work in.
But there's more fees beyond the compact license.
Yes.
Okay, so you're getting the license for one fee, then naming the states and they have fees.
The commission has.
The commission will have fees for certain
For those
things.
states.
And they'll probably be combined with the compact cost for the compact
Okay,
commission
all right,
license.
just trying to get it in my head.
And I'm sorry, go ahead, Aaron.
I'm sorry.
That's okay, we're gonna do,
Are they gonna be reciprocal with these states, or do we set our own fees?
We'll set our own fees.
Set our own fees.
and again, I wanna be clear, the counselor chooses what they
Right.
want to do.
Right.
I just wanted to go back to Leslie's because I'm confused about the telehealth thing. Okay, so if I'm a counselor in Vermont and I'm seeing my patient who's in Vermont and we're doing telehealth, that is perfectly acceptable in Vermont's eyes. So if a Florida provider is part of this compact, you said basically, you know, you do your state, we'll do our state sort of thing. So if a Florida counselor is giving telehealth to somebody in Essex, Vermont, wouldn't that be just, and they were part of this compact, wouldn't they be following Vermont state laws by basically you don't have to be part of our little mini telehealth license thing?
No.
Oh, okay.
You can just be the contact.
You can just be the guy. I thought I heard, I just think I interpreted what you said, which was no, the person in both states still needed to go through like telehealth
I think
stuff.
it's really fair to say this is a very complicated topic, very complicated. And it's hard to keep separate the work we did last year with the compact work.
I was thinking
And it's,
side by side.
and it's states' rights versus compact rights versus the licensees' rights. So it's a very complicated.
So the fact that Vermont is one of the only states that has like telehealth, it's actually advantageous to patients in our state because they can have easy access to providers in all these other states.
That is correct.
And those other states don't need to worry about, those other providers don't need to worry about that.
And access, it improves access, not necessarily workforce, but it improves access.
And if you remember the conversations from last year, we really were talking about, we think this is necessary now because we don't have 28 compacts across all of the licensed profession types. So it's 28 professions, but then as we've been talking about, it's more complicated than that because allied mental health is one of our professions, but we have licensed in marriage, family counselors there, and this compact doesn't affect them. So we need a way to get telehealth for Vermonters with marriage and family therapists because we don't have a compact solution. Down the road, in 20 years, there may be a compact across all of our professions because that does seem to be the direction that we're going.
I think I'm starting to understand it.
It's just multiple ways to the same end, right, to practice. So the benefits of this, I think we touched on this a little bit, is with the clinical mental health counseling education and degree, it's varied. It's a varied degree. That's why they put the standards and the qualifications. And in turn, each state has kind of developed their own requirements for licensure, which means that going from state to state and obtaining a license is not a guarantee and can be frustrating and really time consuming. So what this would allow would be that kind of reciprocity of mobility across state lines without having to reapply in every single state. It's huge for counselors. It's huge for the mental health support and access that folks out there need these days. So that's a huge benefit. We've talked a lot about bringing more mental health counselors into Vermont. Yeah, maybe not, because as many that come in might go out. So it's kind of we don't really know for sure. And I think the nurse licensure compact analysis will be informative about that. The impact on our budget will be less than with, say, the nurse licensure compact because we can charge a state fee for the privilege to practice here. And then the concern is really, the reciprocal discipline that we've spoken a lot about today is ensuring that the commission recognizes that we don't want to be disciplining people in Vermont for violating Texas's laws. So, I'm sorry, Florida's laws.
Texas could join.
They could. So that's all we have today. So any questions?
So can I directly ask, do you support the policy of this compact?
We do.
Okay, thank you. Art, was that your question?
Yes,
Okay.
exactly.
Sorry, I took your
Oh, that's good.
question away.
She's reading Art's mind, that's not.
Tava?
I just have a question, and it's not a big one. I'm looking at this compact map that we have, and maybe I'm colorblind, but I see legislation is enacted, and then I see legislation is not enacted.
No.
It looks like it's the same color.
They're very close in color. I don't think they've done a good job designing the map. And when I saw it last night, I almost put it in our testimony last night, that map. And I didn't because in Vermont, it says there's no legislation enacted. And I didn't feel like that map was accurate. So I think it needs to be updated. But I agree with you, the color coding is hard for those viewing it on a small screen.
So I guess what's the difference between legislation? So legislation is not introduced, legislation is pending. Legislation is enacted, and then legislation not enacted would mean it passed, but it wasn't enacted? What does that even mean?
Not implemented yet?
Not implemented.
Kind of states that had adopted it, but hadn't, had just adopted
There's
it.
none on there.
There's nobody on
I don't see
there.
any on there.
It's not enacted. I mean, it's not,
So-
it doesn't exist.
Right, so, and there's no states with that, so I think it's,
Yeah, no, I don't see any on
I
there.
think not enacted means they haven't even had it proposed or introduced.
okay. But there's nothing in that color, so I don't think it applies.
I think that's all the gray states, actually.
Yeah,
Yeah.
right.
And
Okay.
So that's not legislation,
That's
not,
what Joe's thinking.
This is probably from some other thing they just copied and pasted. Really? And it
I
probably,
think the important thing is this compact is still in its, unlike the other compacts that we've entered, the nurse compact and the physician compact. This compact is at its infancy in terms of implementation. It just barely had enough states be joined to be operational. It's still in its rulemaking phase. And that's something that we like about where we would be joining because we would have a seat at the table in all the decisions. That doesn't mean to say if the policy didn't move forward this year, that would be okay too. And we would be an active and vocal voice when and if we ever join. The other piece that I just wanted to say to this committee is to make you all aware or remind those of you who were here last year, we are working on a mental health study pursuant to Act
171.
It was H661. And that mental health study is going to look at all of the pathways and all of our mental health professions. As Lauren has talked about, it's very complicated. There's multiple different ways in. As a state, we've really tried to expedite and figure out how to get people licensed in the mental health professions. And we've done various solutions. And so we're going to really spend some time looking at it on a holistic, systemic view to see if there's ways that we can make this process easier. It's hard with a profession like mental health, different than nursing or dentistry, where you pass, you go to a nationally accredited school, you pass a national test. There's very strict standards on what the training is to be a nurse. It's different on what the training is to be a mental health counselor. So there's a lot of complexity, and that is another piece. So when you asked whether we support the policy, we do, but part of us also really wants to dive into the work of that study and really understand what the path forward is for Vermont for long-term stability in the mental health licensure. The other piece that I just want to say is the implementation date. That would be the effective date, which in my mind is the implementation date. That would be a place that we would ask likely for an amendment so that we have more time to set up the program. If it's past this session and it goes into effect in September of this year, that's a very narrow window for us to do the education, IT changes, et cetera. They're the rules.
Yes, we can be part of the commission even if we aren't offering the license yet or the privilege yet.
That's what I was gonna ask.
Yes,
Okay.
we could still be part, if the legislation is adopted, I believe we could still be part of the commission.
While you're setting up the program here. Okay. Daisy, and then I do want us to move on.
I am really looking forward to your report and assessment about mental health professions in this state. What's your timeline for that?
December 2024. So I think there are a large number of stakeholders that we want to convene and make sure at the table. We need about 2 years to do that. And so we're really in the ground stages now of finding out who to do the outreach to, what the program plan for evaluation will be, that it'll be a 2-year process given the complexity of it. And folks are welcome to join and listen in and participate as well.
Thank you both very much.
Thank you.
We will obviously be back probably with some questions, and we'll be talking to our friends in Ways and Means as well. So thank you.
Thank you.
Thank you.
So we have had people waiting on Zoom to testify. So unfortunately, we are not going to take a break because someone has to leave at 3, and then we will take a short break potentially. I promise we'll get a break, but we might go through these 3 witnesses first. So Claire brought in. They're in. Do we have Gary Otis and Melissa Willett and Jerry Stevens? Hey there. Good afternoon. Sorry to keep you waiting.
Not a problem. It's been interesting.
Yeah, good conversation, right? So great. So I believe the 2 of you are together. So I'm going to ask you to introduce yourself, and then we'll let you determine who goes first with your testimony.
Great. Can you hear me okay?
Yes, we can.
Okay. I'm Jerry Stevens. I'm from Maine. I'm a practitioner in Maine, and I was born in Vermont. So this is kind of exciting to be doing this. And I'm currently sitting in the desert in Arizona. So as we talk about telehealth, this is what I'm doing right now for the next 7 months. So that's who I am. I'm a practitioner and an educator from Maine.
Great.
So great.
Yeah, hi. Great to be with you all. I'm a licensed clinical mental health counselor here in Utah, and Utah was the 6th state to pass the counseling compact. So both Jerry and I have some experience. Both of us are working with the American Mental Health Counselor Association, which has been in favor of the counseling compact since its inception a few years back. In fact, I was at one of the original meetings that brought the counseling compact into existence, or at least to appropriate some funds to make it possible. I'm currently serving as the chair of the Utah Mental Health Counselors Association and the American Mental Health Counselors Association Counseling Compact Steering Committee, along with Jerry. And we both serve on a number of committees and been involved in the profession for 20 plus years in my case. And Jerry, I know it's been longer for you. Glad to be
Long
with
time.
you. Hopefully we can answer some of your questions.
So I guess my first question is, do you support the compact and why?
Absolutely support it. Let me just jump in right here and sure. So there's a lot of reasons that I support it, and listening to some of your concerns, I get those concerns, but the way that our society is going right now with everybody being so mobile, both clients and counselors, it's been very complicated to be having people go in and out of states, people travel, our military when they're coming in and out of states, kids going off to college. It's been really complicated for people to establish their relationships with their clinicians and then stay with those relationships, because they go into another state and they have to find another counselor wherever they are, or if somebody's just traveling for a short period of time. We've seen it a huge issue with especially college students, and being able to have continuity of care for them because of how mobile our society is at this point. One of the dilemmas has been that I've done a lot of work with, I provide clinical supervision to counselors in Maine, and their clients travel outside, and then they have to start going to each state to figure out whether or not they can serve their client. And so the client calls with some kind of emergency and they don't have rights to be able to do that. That's been really consistent. And so, and then again, trying to even figure out what each state is allowing. And it's great. I love what Florida has done, but there's, you know, like you said, there are two states. There's one, you know, Florida, and then maybe South Carolina that allow this. And other states say, come on in, we don't have a problem. Other states say, not in my backyard, you can't do it. And we don't really know which states those are, and it's constantly changing. And so that's one of the areas for me that the compact would be really powerful.
And just to clarify, Vermont is one of the states that has telehealth. We did quite a bit of legislation last year, so
great. Great.
I'm gonna say we're the leader in that regard.
I love it. I love it. It's good. It's good. But you got to be in Vermont.
Right. Yes.
You know, not that I would mind being there, but yeah. With the technological advances, you know, our young folks coming into the field, the programs that are being developed, the HIPAA compliant programs, they've made it very easy to be able to go from state to state. You know, I stay wherever I travel around for 7 months, and it allows me to still be able to work with people in a safe manner. And I think that's something that's really important, and that's where the compact has been powerful. Especially during COVID, we saw that this can work. And since then have seen all these programs that like BetterHelp and all these programs that do go state to state. And sometimes people aren't really sure, you know, whether they have rights to be able to be working with somebody, even though, you know, somebody might say, oh yeah, I'm in Maine, but they might not really be in Maine. And so there's a lot of chaos and confusion around it. And I think that having the compact will help eliminate that because you know which states that you will be part of part of the compact in. Certainly we know right across the country that there's a deficit of services. And I haven't studied what's happening in Vermont. I know in Maine, our agencies have, you know, some of them have 600 people on a waiting list. And so if we could do cross state telehealth, then that would certainly minimize that and provide more services for people who really need it, especially because some of the specialty programs are out of the state. Being rural the way that we are, being able, you know, to get, you know, sometimes the substance use treatment or the eating disorder treatment or things like that are from other states, and to be able to have that compact to be able to cross state lines would be really, really important. And for me, it's already been identified here is public safety. I just think that if we've got people from other states, it is happening anyway. I mean, we can make believe it's not happening, but people they're doing telehealth without any kind of jurisdiction. They're doing it without licenses. There's no way to really monitor that right now. And so this way, what it does is it does our regulatory boards can at least monitor who's doing it and monitor the kinds of behavior, just exactly like some of the issues that you're talking about, and making sure that the public is safe. So those are some of the reasons that I feel it's really important.
Great, thank you. Gary, did you want to add anything to that? And Melissa, we're not ignoring you. We're coming back to you in a little bit.
Yeah, thanks. I'd be happy to chip in, answer any questions you might have. A couple of things to keep in mind, and I'm sorry, excellent presentations, excellent questions. But as far as I can tell, there is no counseling compact license. There is a request to join as an individual and apply to the counseling compact to participate. And then it is a separate process that builds on that to have the individual apply for privilege to practice in the given states that they're going to apply through the compact to do that. So the license only is the home state license. And, Vermont will maintain a complete sovereignty over their own licensing rules and requirements. And I think that's an important distinction to kind of bear in mind that we're only talking about privilege to practice. And if a counselor applies to, if I'm in Utah and I want to apply for a privilege to practice in Vermont, then I'm going to have to meet Vermont's requirements through the counseling compact and pay a separate fee to practice, to have the privilege to practice in Vermont. So some things to think about in that context. By the way, Utah is also doing that telemental health. So yes, Vermont, you're the leaders and we're following along.
Great.
I think it's going to pass in this legislative session. We talked about the map, and just to let you know, there are no black states on that map because that indicates, as far as I understand it, a state that has considered legislation and they have voted it down. They don't want to, they have opted not through their legislature to not join the counseling compact. As far as I know, that has not happened yet. So that's why there are no black states on that map. I did want to mention, you know, I'm in favor of the compact. I'm certainly delighted to spend some time with you. I thought this session has really been outstanding, but I thought I'd give you a few perspectives of why this was appealing to our Utah state legislators. The first one, and I put it in the context of both portability and reciprocity. Portability means that if I move to another state, I don't have to go through that state's hoops to get licensed. In other words, my license in Utah will be sufficient evidence as a fully licensed counselor to practice, for example, in Colorado, since Colorado and Utah have now both joined that the compact. And we are interested in that here in Utah because people are moving to Utah in large numbers, and some of them are counselors and some of them are fully licensed with great expertise. And they don't need to jump through Utah's licensing laws and go back and check the number of hours that they have for this or that, their license will be the evidence that they are experienced clinical mental health counselors and are authorized. They still have to make an application. They still have to pay Utah fees. Utah becomes the home state for them. But this is an important factor of why our legislators were interested in this. A couple of other things, though, that I think are really important, and Jerry already mentioned this, continuity of service today is a huge thing. Have an individual that's going to school here in Utah, they're home for the summer. What do you do in terms of making sure that they have continuity of care? How do you best support them? And again, that would be especially true. We found that this is important in the context as you in Vermont are kind of in a hub of many states that are right around you. I'm guessing, you know, you're like us here in Utah, although we have a lot of rural areas that maybe you don't have, but a lot of our rural areas are right next to cities in other states. And so to be able to increase public access to mental health services was certainly an important factor for our legislators. I think the other issue, and I'm a retired military officer, but was really this idea of military individuals moving, and particularly also their spouses, some of which there are military people that are counselors, but there are spouses that are counselors. And again, that kind of goes back to that portability issue. So I think these are some of the real key issues that our legislators found appealing. We didn't have really a whole lot of controversy about it. We didn't have a lot of negative, and it did go through our legislature faster than we expected. And you know, as Jerry and I sit on the American Mental Health Counselors Association steering committee for the Counseling Compact, we're constantly looking for what are the objections. And I think, you know, you've raised a number of issues. They really do need to be addressed. But in terms of really finding objections to the Counseling Compact, I don't have a list. We have a lot of why fors and how comes, but not a lot of objections once they work through. Now, again, the Counseling Compact Commission will have to deal with a number of these issues, and they're going to have to sort out a lot of the details. But I think from our vantage point here in Utah and also from the American Mental Health Counselors Association, this is a step in the right direction. And as you have pointed out in our meeting today a number of times, this is a trend that isn't going to be reversed anytime soon in terms of both portability and reciprocity.
Yeah. Great.
And can I add one more thing too?
Sure.
So one of the dilemmas that you've already identified also is the inconsistency in state requirements for licensing. And so one of the good things about having a compact like this is that any state that joins the compact, we know what their minimum standard is. They may have other standards, within their state, which some will, but to join the compact, they have to have met that criteria. And then an individual who then gets into it has to meet the criteria. And so we know what we're talking about across the country. Much like what we already see with social workers, but we don't see that in the mental health field. And so that it's going to create some consistency for us.
Yes.
Great, thank you. So we have two quick questions, and then I want to give Melissa an opportunity to provide testimony. So, and Gary and Jerry, you're welcome to stay for Melissa's testimony or jump off, whatever works for you. So Daisy and then Art.
It's so great to have you with us today and really interesting to be learning with you. My question is around, I don't know if with your work on your committee, you can speak to workforce trends. I'm familiar with groups like Innovatel and just kind of curious what you see your workforce in Utah doing. Are they in private practice with local providers, or is there anything we should be worried about with providers maybe going to a national organization like Innovatel and providing to clients through somewhere like that versus local agencies?
Yeah, I actually happen to sit on the Utah Behavioral Healthcare Workforce Work Group, which is a real mouthful. But yes, we're not seeing any dramatic trend changes at this point. We're concerned about the need for more what we refer to here in Utah as mental health therapists, which includes all of the behavioral health arena fields. But no, we're not seeing any major shifts, so to speak. Certainly individuals are going to have the right to do what they do. And, we already have these nationally organized companies that are providing services and recruiting people out of the different states. But that's going to be an individual decision that the individual is going to have to decide to do. Our state is looking at some of these things. For example, we don't have enough psychiatrists. So there are national associations, businesses, I should say, that are coalescing psychiatrists and now wanting them to get licensed in Utah so they can provide psychiatric services, which is in demand, obviously. But so is all of the mental health, behavioral health needs for the public. Does that answer your question?
Yeah, thank you.
Art?
Yes, thank you. From what I can see and hear and all that I've heard today seems to support the compact. But I'm wondering what personal financial component is there to a gentleman in Utah providing telehealth or counseling services to somebody in Vermont and how that works. There's got to be some sort of financial incentive for you to join the compact, and I wonder, beyond the scope of somebody from Utah moving to Vermont or going to school here, or from Arizona or Maine doing the same thing, there's got to be something where you say, well, gee, I might be able to get 10 folks from Vermont on telehealth and counsel them, which would be a huge boom here, I think. What about that? What do you do? What physical thing do you do to get business in other states?
Yeah, it's an interesting question. And to answer it specifically, I'm probably never going to have a privilege to practice in Vermont. It's too far away, and I'm not going to get 10 people. But out here in the Western United States, where we're so closely located to Colorado, Arizona, particularly California, Washington State, Idaho State, there is potential. And it normally comes because somebody knows somebody. I can't tell you, most of my practice is based on word of mouth. And I do have people out of different states that want to talk to me, and I can't serve them as a mental health therapist. I can talk to them, but I can't serve them as a therapist because I don't have the privilege to practice in those states. I've had a number from Texas, oddly enough. Go figure.
Texas.
Go figure.
I'm sorry, but
Go figure.
I do have an appointment coming up. So I'm probably going to have to sign off at this point. And
Great,
thank you so much.
Thank you very much, and thank you, Jerry. And let's bring Melissa on. Thank you, Melissa, for waiting. We appreciate that. If you'll introduce yourself. Sure.
Absolutely. I'm Melissa Willette. I'm the New England Regional Liaison for the United States Department of Defense State Liaison Office. And I did provide a letter of support and written testimony to the clerk. So you should have a copy of that, but I'd just like to deliver some oral testimony that is a little different, hits the key points, but
please.
Yeah. So just testifying in favor of the policies reflected in House Bill 62, which addresses licensing issues affecting our service members and their families. There are many unique requirements that come with a life of service in the United States Armed Forces. Those responsibilities are not only bestowed on the service member, but also on the spouses and children of those actively serving our great nation. The Department of Defense understands the challenges that oftentimes present themselves to military spouses, and reducing those burdens is a priority of our department. The annual percent of the military spouse population that moves across state lines is 14.5%, compared to their civilian counterparts at 1.1%. As much as 34% of military spouses in the labor force are required to be fully licensed, and of those spouses, 19% experience maintenance difficulties. For military spouses, professional licensing requirements remain an enduring challenge. Due to the nature of the military, most active duty service members change duty stations every few years. Not only is the service member expected to reacquaint themselves with a new installation, unit, and command, the spouse too is forced to reinvent themselves professionally. The Interstate Counseling Compact will allow counseling professionals to transcend these boundaries. Frequent moves and cumbersome licensing and certification requirements limit career options for military spouses. Removing these barriers, creating reciprocity in licensing requirements, and facilitating placement opportunities can help a military family's financial stability, speed the assimilation of the family into its new location, and create a desirable new employee pool for a state. To address license portability for military spouses, states have turned to occupational licensure interstate compacts, which streamline relicensing between member states of a compact for all practitioners in an occupation and provide specific support for military spouses of relocating active duty personnel through provisions recognizing unique requirements of military life. This is significant for the military community in that, along with active duty military spouses receiving the benefit of compacts, active duty members of the reserve component, and reserve component spouses, transitioning service members, and other veterans benefit from the mobility provided through the compact. To date, 17 states have signed interstate counseling compacts into law. The compacts have the potential to significantly change the way counselors can practice and will provide continuity of care as well as the ability of counselors to reach underserved populations. Vermont, very much a rural state, could benefit greatly from the policies outlined in the compact. If passed, the policies reflected in this legislation would preserve Vermont's authority to regulate the profession, but the overall opportunities and quality of life for both counselors and clients could be amplified. When looking at the reasons many service members choose to don the uniform, many will tell you it's for family, community, and country. Military service, however, can only continue with the support of that family in their time of need, to include professional development and security. The Interstate Counseling Compact, while vital for our communities, is also critical to the mission of the Department of Defense and the overall retention of our military men and women. With the above stated benefits in mind, we look forward to engaging in efforts that will create increased quality of life for all populations we aim to serve. Vermont's military veterans, service members, and their families make significant contributions to our communities and our workforce, and the Department of Defense remains committed to working with our partners on the local, state, and federal levels to recognize the sacrifices they make on our behalf. On behalf of the Undersecretary of Defense for Personnel and Readiness and the Deputy Assistant Secretary of Defense for Military, Community, and Family Policy, as a service member myself and a military spouse, I am also grateful to the committee for your work on behalf of those who have served and continue to serve. I thank you for your time today and look forward to the positive outcomes of these policy changes.
Great. Thank you, Melissa.
You're very welcome.
And as she said, there's more information on our committee page from Melissa. Does anyone have any questions? Mari?
Just a comment, and I wish I had done this when the other witnesses were here, but as a healthcare professional who has applied, is a member of the Nursing Compact, and has attempted to apply for licensing in other states, I can affirm that the process is different in every state, and in some states it's really onerous and very expensive. So I'm, as a practitioner, speaking out in support of the compact.
Thank you. Any other?
I have a question, but not for Melissa. Thank you, Melissa, though. Yeah.
You're welcome.
So who are we directing the question to?
The question.
Okay, can we,
effective?
let's wait until we're done with Melissa. Any other questions for Melissa at this point in time? Oh, great. Melissa, again, thank you for sending the testimony. Thank you for staying online, and we appreciate your support. Thank you very much.
Have a great afternoon.
Thanks, you too. Leslie, you have a question for OPR?
I think so. You were talking about effective date and, doing an amendment. And I was just noticing on our agenda that we have a possible vote on Friday. So I was just curious.
Yep, so it's on there as a potential.
Yeah.
Friday is a long way away. So we'll see
away.
what happens between now and then. But
Yeah.
we will work with OPR to get the language that they're asking us to amend.
That's all I was
we'll
hoping.
Go from there.
To be able to, because I'm ready to vote. Just saying.
So I would love to continue our discussion on this, but we do have testimony at 3:30 and I think we all need a break. So if everyone can be back here at 3:25 to be ready, and